And we are recording. All right. A very good day to you all and welcome. My name is Ron Quaranta and welcome to our inaugural Wall Street Blockchain Alliance Call the Lawyers podcast. And before we get started, please note the usual disclaimers. This is not legal or professional advice. This is for information and educational purposes only. Our inaugural guest, my friend and member of our legal working group, Mr. Kayvan Sadeghi, partner at Schiff, Hardin. Kayvan, how are you?
Doing pretty well. Happy to be the guinea pig for this inaugural episode.
Oh, it's going to get better from here. Well, look, we'll keep it brief and everyone will hear that this is short form kind of format podcast. A couple of things real quickly. So talk about the practice. I mean, you've been involved in a lot of different things for quite a while. And then ultimately, tell me what got you involved in blockchain. I know the story and I love hearing it, but I'd love to make sure that the audience hears it as well.
Sure, of course. So I've been doing securities litigation and other complex litigation for about 17 years now. Got into the blockchain side of things in late 2016 through actually one of the advisors to the Wall Street Blockchain Alliance, Josh Klayman, who many of us know. And it was a natural fit for me. I had a bit of a programming background before I was a lawyer. And so having moved to the sort of financial market side of litigation, the technology side sort of followed me along, and it's a marriage that makes a lot of sense to me.
But you're not coding anymore.
I'm not coding anymore. I know enough to know that there are people who can code a lot better than I do.
Excellent. Well, one of the topics we talk about a lot, it's been a busy few years in the crypto and blockchain space. And really, we know COVID and coronavirus has really delayed certain things moving forward, and everyone's really concerned. But one of the things that has popped up recently, and it's the word I keep hearing in a lot of our meetings, is Telegram.
Right.
Telegram issued an ICO, I believe it was in 2018. They issued billions or a billion or whatever it may be in grams and made lots of money. And then the SEC stepped in and said, hang on a second. So them being in the news recently, the court brought forward some decisions and some commentary weighing in on the side of the SEC. And just in a few words for the layman, what's that decision? How important is that? And what does that decision mean for the future of token issuance?
Sure. So one of the key features here in the Telegram case was that Telegram did its offering using a SAFT framework, which many of this audience I think will be familiar with, where there was an initial offering round to accredited investors that Telegram acknowledged was a securities offering. And then they were planning to do a distribution of the actual Gram token and wanted to distinguish that subsequent distribution of the token from the initial offering that they acknowledged was a securities offering to accredited investors. And the SEC disagreed and said this is all part of one offering and the whole thing should be considered a securities offering. So that was the issue that was up for decision by Judge Castell in the Southern District. And it was on a preliminary injunction, but he decided, and his holding is that this was really all one integrated scheme. And I think the important concept here, people talk about the Howey analysis a lot and what is an investment contract that makes something a securities offering. And I think there'd been a lot of discussion around what it means to be an investment contract, and people get wrapped up in the word contract there and start looking for some particular contractual rights and the like. And one of the key issues with Judge Castell's decision was to say, one of the aspects of an investment contract, something that can qualify as an investment contract under Howey, is a scheme. And that's not scheme in the pejorative sense. It's just an integrated set of understandings and agreements, and it doesn't have to be embodied in any particular contract or other set of documents. And so Judge Castell found here that there was an overall scheme that was understood from the outset to involve the ultimate distribution of these tokens to the public. And so that whole scheme was considered a securities offering. And as a result, Judge Castell enjoined Telegram from distributing the tokens. The second piece, you mentioned there were two decisions. The second piece, Telegram came back afterwards and asked Judge Castell to, in their words, clarify that ruling to hold that his injunction did not apply to distributions outside the United States, that essentially his ruling was limited to the territorial reach of the United States. And he declined to enforce that limit for a couple reasons. I think one, he notes that it's unclear how that would be enforced and whether there would be flow back into the United States. But he also spends a while sort of smacking around the Telegram Council for not having raised the issue sooner, saying you saw what the proposed injunction was at the outset of this dispute. You never raised this or gave the SEC a chance for discovery on that issue, and so I'm not going to hear it now.
Right. And just a couple of things on that point, as a non-attorney, something that really percolates to the top for a lot of us, having been and seen the token offering world, the judge made an interesting point that I think a lot of non-lawyers lose track of, which is that scheme also includes intentions, even of buyers, as anticipated in that, right? And it really puts to lie the idea that a token issuer can put forward the idea that this is just a token, it's just code, and it is not a security distinct from intention, distinct from all the stuff that you're talking about. So how does that change what token issuance will look like? We've had this conversation in the past, and will issuers look at this and say, I need to be compliant? And that takes a whole bunch of issuers off the table, given the legal and regulatory costs associated with that. What's your perspective on filling out that picture?
Sure, and I think what Judge Castell gets down to is that you have to look at the economic realities. So you're not looking necessarily at anyone in particular's intention alone. You're not looking at how the documents are drafted alone. All of those things may fold into the analysis, but you're looking at a bigger picture, and it's going to be a totality of the economic circumstances that will drive the decision. I think for issuers going forward, that makes it very difficult to see any way that you can use the same token for a fundraising purpose and also for a downstream functional purpose or consumptive purpose on your blockchain platform. There may be ways to do it, and there may be situations where the economic realities suggest that that is not one integrated scheme, but it's not as simple as you can document it one way or another, and that documentation difference will govern, which is sort of what the SAF was trying to do, was say, we can't do an ICO, but if we document it this way and structure it in a certain way, we can accomplish some of the same purpose in a different structure. And that is what I think has been cast into doubt. So at the moment, I don't think there is any clarity on a way that you could have comfort would be accepted as using the same token for fundraising and for downstream use without considering the entire process, at least at a very high risk of being found to be a securities offering.
Right. So thank you for that, Kayvan. Let's pivot for a little bit. You've been a litigator, you are a litigator, and one of the conversations that we've had in the wake of so much innovation, blockchain, crypto assets, and even other technology innovations, AI, and not to get too far afield, machine learning, all of our roles are evolving. Mm-hmm. How's the role of litigator evolving? What's coming next? And we have a lot of relationships with educational associations and with different schools and law schools. And what do you see the role of litigator becoming over time?
Sure, and I think it's a good question. I think one of the things that litigators have to be able to do, and this has not changed, it is take complicated subjects and very complicated factual circumstances and try to make them simple and turn them into a story that is persuasive. At the end of the day, technology changes very quickly. Judges do not. And juries also, usually will not have technical mastery of all the nuances. We don't have specialized courts for most things. So you have to be able to boil down all the complexity into something that fits familiar patterns and that people can understand. And what I think has changed is what's required of litigators to be able to competently do that. As technology keeps changing, staying on top of what's happening gets harder and harder. And there's a double-edged sword to all of this, because if you get too wrapped up in the weeds, it's easy to forget what your audience might not understand. It's easy to forget what you're taking for granted, what you're just glossing over that are real gaps in most people's understanding. But at the same time, if you try to oversimplify, then you put yourself at a lot of risk for opening up the other side to be able to really rebut your argument and show that what you're saying isn't completely accurate. So I think as technology keeps changing more rapidly, litigators have a very difficult job to be able to sort of thread that needle of having the technical competence to be able to really put together an accurate story, but to be able to simplify it for audiences that don't have that same background.
Do you see that changing in law schools, for example? And the reason I bring that up is we've had conversations with some law schools, and they're particularly when the phrase smart contract started popping up everywhere a few years back, and trying to weave technology understanding, maybe not at the coding level, but into law students who will be litigators in the future. Is that something you're seeing evolving as well?
Yeah, I think in some ways it happens at the law school level. In some ways it's almost more important on the law firm level, because I think the people we see coming up now as the more junior associates, and the people I know who are younger than that in college now, or like, tend to have a degree of technical competence and understanding of computers and other technology that often vastly exceeds some of their older colleagues. And so that presents a difficulty for making sure that the older colleagues actually understand what's happening and are able to convey it accurately. So in that sense, I do think there's more of a blending of technology into law that's going to happen in law schools, but the difficulty of conveying some of those topics may be more acute at the law firm level and at higher levels.
Got it. So when I say to my business colleagues that a lot of my friends and colleagues are litigators, they don't get the picture of what a litigator's day-to-day is. Usually it's some imagery of your life day-to-day is a show of Boston Legal, for example. What does a litigator's world look like on a day-to-day basis? And the reason I ask this very specifically, appearing in court, for example, look at the world we're living in now with COVID-19 and lockdowns. How is the litigator coping with that? And how are you coping with that on a day-to-day?
Sure. I think maybe to start out with that last question, I think one of the things about being a lawyer in general in a circumstance like this is we realize how much less crucial and less on the front lines what we do is than some of our friends and relatives. Anybody who has anyone close to them in the medical profession, they're really saving lives. They're really on the front line. We can sit behind a desk in a computer and do a lot of what we need to do that way. We can interact with the court remotely. So it really shines a light on the fact that there are other people who are really taking, the hero role here, and it's not us. As far as how it does impact us, a lot of what a litigator is doing is preparing for uncertainty. When you go into court, you don't know what the judge is going to ask. You don't know what their pet issues are going to be, or where they're going to have a lack of understanding, or maybe agree more with the other side. So you really have to prepare 10 times over for, it's hard to convince clients who haven't seen it before why it takes so much preparation for a very short conference. And you prepared for 20 different topics, the judge only raised 2 of them, but you don't know which 2 it's going to be. Right. And so that sort of preparation, I think, is just compounded in circumstances like this. The uncertainty around how court proceedings are going forward. We see new orders coming out every day, changing the way the court procedures are working. Obviously, our clients and our clients' potential adversaries are all thrown into various levels of uncertainty because of this too. And so it just adds complication, and the only real way to deal with that is more preparation.
Got it. So we're running towards the end. We usually keep these relatively short. You're one of the core members of our legal working group. I think you might have been one of the actual first members of our legal working group. Any predictions about what's coming down the pipe around Kik and Telegram and some of these others? Anything you want to talk about from the perspective of what you think the landscape's going to look like?
Sure. And I think the other major shoe to drop recently that will have some impact is the series of private securities class actions that were filed last week. And there are a series of them against a number of issuers and a number of the trading platforms. And those cases, I think, will be interesting, and they really put a finger on some of the nuances of the Telegram decision. Telegram makes clear that the gram itself is not the security. It's this overall scheme. Yeah. It's very unclear what that means, and there's already an amicus brief that's been submitted for consideration by the Second Circuit on appeal in Telegram that points to that issue among a couple others. But the uncertainty around what that means, if the gram itself is not the security, well, then now what? Especially for other tokens that are out in the world already. It's one thing with the grams that hadn't been distributed yet, but when you look to other tokens that are out there trading, if the entire scheme of getting them to the public was the securities offering, but the token itself is not a security, what does that mean for the trading platforms? Does that mean they are not facilitating trading of securities because the token itself wasn't a security and therefore they don't have to be registered? Or will the token be found to embody the securities offering in some way such that they should have been registered? There are going to be a lot of those sort of questions that come up that I think the private cases will start to resolve. I think we're going to have a lot of issues around jurisdiction as far as the reach of the US laws. Those issues are going to be front and center in those cases as well. Now that we're starting to have some clarity on that the courts are going to take a broad view of what constitutes a securities offering here, there's going to be a lot of question about how far those US laws reach and what connection to the US is sufficient to put yourself within the reach of the SEC or other authorities. So those are some of the things I think we're likely to see coming up next.
Yep. And if I remember correctly, and again, it's a fast moving space, I think one of the 11 in the class action has already moved to settle. Is that something you saw as well?
I saw some note. I haven't seen anything concrete. I think I did see some indication of that, but I expect we'll see some of those cases. There are a lot of those cases. There are 11 separate ones, and a number of them have multiple defendants, both the companies and the individuals. I expect we may see some early settlements. We'll see some that I expect will probably fight for quite some time. So yeah, something tells me we'll be discussing those again.
We absolutely will. So I will end it there. I know you've had several meetings today and you're very busy, so I appreciate the time. Your most important meeting, I'm sure, is our virtual happy hour at 5. So looking forward to seeing you there. But thanks again, and we'll post this as soon as possible. Thanks so much, Kayvan.
Of course. Look forward to talking to you soon.
You got it.